For decades, family law was built on an adversarial structure. Assigning blame was required to dismantle a relationship. Today, a streamlined administrative pathway replaces it. The Matrimonial Causes Act 1973 and the Civil Partnership Act 2004 established the legal foundation for dissolving adult relationships in England and Wales. The Dissolution and Separation Act 2020 restructured these legacy statutes. It removed the adversarial requirement to prove fault. Previously, an applicant had to prove one of 5 facts, like adultery or unreasonable behavior. Now, those evidentiary hurdles are gone, replaced by a single statutory standard, a statement confirming the union has irretrievably broken down. This blank procedural timeline maps the modern route. Without the need to argue over blame, a successful application now relies entirely on strict adherence to statutory waiting periods. Practitioners no longer spend initial meetings gathering evidence of blame. Instead, strategy centers on managing these strict timelines and facilitating parallel financial resolutions. The procedural clock does not start on the wedding day. On our timeline, a locked gate appears at the 1-year mark. Under the Matrimonial Causes and Civil Partnership Acts, an application cannot be made within the first year of the union. This bar is absolute. Parliament designed it to prevent over-hasty decisions and force reflection. Once that 1-year threshold is crossed, the timeline progresses to the application stage. The 2020 Act introduced a major innovation here. Applications can now be made jointly. Terminology reflects this shift. The instigating party is now termed the applicant, replacing petitioner. If an application is made, a respondent has very limited options to dispute it. A defense is permitted on 3 narrow grounds. The court lacks jurisdiction, the marriage was invalid, or the union has already legally ended. Because the 1-year bar is absolute and joint applications are available, client intake focuses on early conciliation rather than immediate litigation. Once issued, our timeline shows a progress bar filling up, representing the first major statutory waiting period. The statute mandates a minimum wait of exactly 20 weeks. This cooling-off window gives parties crucial time to negotiate financial and child arrangements. When those 20 weeks expire, the applicant can trigger the next major milestone, the conditional order. This term is the modern legal replacement for what used to be known as the decree nisi. Following the pronouncement of the conditional order, our timeline introduces a second, shorter progress bar. This secondary waiting period lasts for exactly 6 weeks and 1 day. This progress bar connects to the final node on our timeline, the final order, which officially dissolves the partnership and replaces the legacy decree absolute. Applicants must watch the calendar closely. They have a strict 12-month time limit to apply for the final order after the conditional order is granted. If the applicant fails to apply within that 12-month window, the respondent gains a procedural remedy. They may apply for the final order themselves after an additional 3 months have passed. These strict 20-week and 6-week gates dictate case management. Practitioners must proactively synchronize the financial remedy timeline with this primary divorce track. The standard timeline leads to the dissolution of the marriage, but that is not the right strategy for every client. An alternative mechanism is sometimes required. A branching pathway drops from the start of our timeline, revealing the primary alternative, judicial separation under Section 17 of the Matrimonial Causes Act. This route strategically bypasses the 1-year absolute bar, allowing application at any time. This makes it a crucial option for clients whose relationship breaks down in the first year, or those with strict religious objections to formal divorce. The legal effect is specific. It terminates the legal duty to cohabit, but does not dissolve the underlying marriage or civil partnership. Because the marriage remains legally intact, neither party is permitted to remarry. The financial remedy landscape is also distinct. While the court can make most financial orders, pension sharing orders are strictly prohibited in a judicial separation. This route provides a specific tool, allowing practitioners to secure legal and financial protection for vulnerable clients, without crossing the threshold of final legal dissolution. Zooming out, the completed master timeline reveals the full procedural architecture. A bracket spans the 20-week cooling-off period and 6-week wait, showing a minimum span of 26 weeks. That is the absolute fastest a standard divorce can be achieved under the 2020 Act. The core of family practice has changed. The focus is no longer proving fault, but skillfully managing administrative timeframes and parallel negotiations. Communicating this reality requires precise adoption of the new statutory lexicon: applicant, conditional order, and final order. Mastering these distinct timelines, absolute bars, and alternative routes allows practitioners to deliver efficient, compliant, and non-adversarial resolutions for their clients.